cross-examined. And again, at the end of the hearing, ma'am, if you have anything else you think I need to know that didn't come out during your general testimony because you're a pro se litigant, I will allow you to testify to it in a narrative form, so long as it's relevant. So at this time, Mr. Starr, you can call your first witness, please. Thank you.
I'd like to call my client, Mr. Guy, please.
Yes, sir.
Okay,
Mr. Guy, state your full name for the record, sir.
Stanley Allen Guy.
All right, you may proceed.
All right, and Mr. Guy, will you state your son's name in this case?
LeZabrion DeJour Williams.
Okay, and did he turn 18 years of age on December 13th, 2020?
Yes, he did.
And did he graduate high school in May of 2021?
Yes, sir.
And to your knowledge, since your son graduated high school, have you continued to have your wages garnished for the purposes of child support?
Yes.
Okay, and was the last child support payment you made, did that occur in September of 2022?
Yes.
Okay. Now, do you remember uploading to our case management software a document called a financial activity report that you received from the Attorney General's office?
Yes, sir.
All right. To your knowledge, did you alter that document in any way?
Not at all, sir.
Okay. Your Honor, I'd like to submit that document into evidence. I emailed it to you and I believe the Attorney General, but they should have it as well.
You emailed it to Belinda?
Yes, I did.
All right.
State has no objection, Your Honor.
Okay, I must have left it on the bench. Can you go grab it for me, please? Yeah, I'm sorry. I had to move off of the bench and move over here. So
there's also
it was underneath.
Okay, there's also the state disbursement record. We're going to just enter that into the evidence as well.
All right, I've got it here. Just
Okay.
a second here. All right, here we go. And so I'm remarking this as respondent father's number 1. All right, folks, I know you can't see it very well, but this is the respondent father's number 1. It is the accounting of the child support that was paid to the state disbursement unit in this case. Is there any reason this should not come into evidence at this time, Mr. Diamond?
No, Your Honor.
All right, Ms. Williams, is there a legal reason this shouldn't come into evidence, ma'am?
No, Your Honor.
Right from the start, the father's side came in strong with hard evidence, and the court admitted it. This is huge, because once financial records are officially entered, they carry serious legal weight, shifting the case beyond a simple he said, she said. What stands out is how calm the father remains as the judge confirms the overpayment figures, a demeanor that only strengthens his credibility in the courtroom. But it raises a question: does staying calm give parents the upper hand in these battles, or is there value in showing more emotional fire? Either way, the spotlight now shifts to the mother as she takes the stand under oath. The respondent father's exhibit is admitted. You may proceed.
All right, Mr. Guy, did you see at the end of that document, the Attorney General's office states that you overpaid child support by $13,476.88?
Yes, sir.
Does that amount seem accurate to you?
Yes, sir.
Okay. Do you also remember submitting to our office a document titled Texas Child Support Disbursement Unit Payment Record?
Yes, sir.
Okay, and to your knowledge and belief, was that document altered in any way?
Not at all, sir.
And do you believe the information on that document is correct as well?
Yes, sir.
All right, I'd like to submit that as Petitioner's Exhibit 2, Your Honor.
All right, I'm marking this as respondent father's RF2.
All right, Mr.
All right.
Go ahead.
Any objection to RF2 coming in evidence at this time, Mr. Diamond?
No, Your Honor.
All right. Ms. Williams, is there a legal reason that this information should not come before the court this time?
No, sir.
All right. RF2 is admitted. You may proceed, Mr. Starr.
Okay. Since your son graduated high school, Mr. Guy, has Ms. Williams paid you back any of the overage amount of child support?
No, sir.
Okay, would you like the court to award you a judgment of $13,476.88 to make up for the excess amount of child support that has been garnished from your check?
Yes, sir.
All right, and would you like the court to award you attorney's fees since you had to hire me to get this money back?
Yes, sir.
Is there anything else you think the court should hear today, Mr. Guy?
No, sir.
I have no further questions for this witness.
All right. Mr. Diamond.
No questions, Your Honor.
All right. At this time, Ms. Williams, technically you're your own lawyer. I always have pro se litigants, if they have questions, they have to run them through me because I want to make sure that they're relevant. So at this time, ma'am, as your own legal representative, do you have any questions, Mr. Guy?
No, I don't have any questions, sir, but I do have a statement.
All right. Well, that's at the very end, ma'am. Thank you.
Okay.
All right. So, Mr. Starr, you can call your next witness, please.
All right, I'll call Ms. Williams, please.
All right, Ms. Williams, take your full name for the record.
Bertina Levette Williams.
All right, thank you, Ms. Williams.
Star.
Okay. How old is your son now, Ms. Williams?
He's 20 years old.
All right. And when did he turn 18?
He turned 18 and I think it was 2020 of December 13th.
Okay. And did he graduate high school of May of 2021?
Yes, he did.
Okay. Now from September 17th, from September 7th, 2011 to September 27th, 2022, did you receive child support payments for your son?
I did, sir.
Okay. And after your son graduated high school, did you continue to receive those child support payments?
I did.
All right. Have you returned any of the excess money since?
There it is, a flat-out admission that she kept the overpaid support. This is a pivotal moment, as the father's attorney has now secured both key elements, financial records confirming the overpayment and her own words confirming she never repaid it. Legally, that's textbook groundwork for a judgment. But emotionally, you can hear her defending the money as if it were still morally hers. It raises the question, should morality outweigh legal obligation in family court? Now, let's hear how she tries to justify holding on to $13,000 that was intended for her child.